Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Hello and welcome to a special interview for The Wire. How should we assess and analyze Monday's Supreme Court order on electoral bonds? And secondly, does it suggest a new assertiveness on the part of the Supreme Court, a fresh determination to stand up for the rights of Indian citizens? Those are two key issues I shall take up today with one of the most illustrious former judges of the Supreme Court, Justice Madan Lokur. Justice Lokur, not only has the Supreme Court dismissed the State Bank of India petition requesting extra time to reveal electoral bond details, but it's ordered that they must be handed to the Election Commission by close of business today. Secondly, it's demanded that the chairperson and managing director of the bank file an affidavit of compliance. And third, the bank has been given notice that the Supreme Court could initiate contempt proceedings for willful disobedience if the bank does not comply. To most laymen, that feels like a slap on the bank's face. How do you read it?
Well, it is, in a sense, a slap on the bank's face, in the sense that, you see, the bank was supposed to give the information by a particular date. I think it was 5th or 6th of March, right? And they had sufficient time to tell the Supreme Court that, listen, we can't do it, okay, because the order of the Supreme Court was given around the 14th or 15th of February. So there was really, it doesn't make too much sense, for the State Bank to have come virtually, 2 days or one day before the deadline was about to be over, and tell the Supreme Court that we can't comply with it. That is why one of the things that the court asked the State Bank was, what were you doing for these last 3 weeks or so? Right? You should have tell us what you were doing, and why do you find it difficult to comply with our order? Now, when there was no convincing answer, and obviously there could not have been any convincing answer, the Supreme Court said, well, you better comply with it. We are giving you time, 24 hours. By tomorrow, you comply with it. So the bank has really been put in its place, that you can't fool around, with us. When our orders are clear, you have to comply with it.
From your memory as a judge, both at the Supreme Court and at High Court levels, is it often that government-owned companies, a public sector bank, is rebuked in public by the Supreme Court in these harsh, strong terms?
No, I have not come across any such case. There may be one or two, in maybe about 10, 15 years, there may be one or two. But I mean, this sort of willful, disobedience is not very usual.
Let's, Justice Lokur, look at some of the details of what the Supreme Court said yesterday, Monday. The State Bank argued that it needed extra time to match and collate details which it already possesses. This is what the court said in response. We did not ask you to do this matching exercise. We have simply directed a plain disclosure. The grounds on which you seek additional time do not accord at all with the directions we issued. In other words, the court said to the bank that the bank is deliberately complicating what it's required to do, thus creating an excuse for not doing it. That is a pretty embarrassing rebuke, is it not?
Yes, it is. It is. You see, because the directions were very clear, that you tell us the details of the donors and you tell us the details of the recipients. That's it. That's all that the Supreme Court had asked for. Now, that information, however they may have kept it in a sealed cover or whatever they say they may have done, is available with them. So they just have to give it to the Election Commission. That's it. It doesn't require, 3 months or 2 months or whatever it is. And when the Supreme Court has said you do it within 24 hours, that is by the close of business today, and I have no doubt that they will do it. At least I hope they will do it, because it's not such a complicated affair. Then if it just takes, a day or 2 days, and in any case they had 21 days before this, I really don't see why, they're shying away from giving this information.
Would laymen, not
Now,
the judges of the court, but would laymen be correct in drawing the following inference: that the bank was deliberately complicating a simple task because it wanted to provide an excuse for not doing it? And that in turn was because they wanted not to reveal information that would potentially be embarrassing, I presume, for the government. This was a charade being put up, possibly to protect the government. Would laymen be right in drawing that inference?
well, partly yes and partly no. You see, it's like this. The Supreme Court was looking at two things. One is the transparency issue, right? Now, so far as that is concerned, the orders of the Supreme Court were very clear, and the state bank should have given that information, which it could have given within no time. The second aspect that the Supreme Court was looking at, which is equally important, was the quid pro quo aspect. Okay. Who has given how much and to whom? That's the
And
quid
why?
pro.
And why?
Why will follow, because if the recipient does something, then you can put two and two together and come to a conclusion. Now, that second aspect is the matching aspect. All right. Because I don't know how, the bonds were purchased and what was the procedure that was actually followed. But it is possible that, say, for example, 100 bonds have been printed and only, say, 80 of them have been sold. Okay. Now they know, the state bank knows that who are the purchasers of these 80 bonds. Now, whether they have been given to a particular political party, party A or party B or party C, that also they will know. But they will have to match these 80 bonds out of 100 to a political party or to 3 or 4 political parties and say that, well, the balance 20 were not even utilized. That's how you come to that quid pro quo aspect. Now, for that, perhaps, I don't know, the state bank says that, oh, we need to match. And that may take some time. It may take some time, okay. But then it can't take so much of time, that up to 30th of June and all that.
Quite
Maybe
right.
it can be done within maybe 10, 15 days, maybe 20 days, because we are not talking about too many bonds.
You're saying something very important. Even for the more complicated exercise of matching purchaser with recipient, you believe it can be done in 10, 15 days' time. It doesn't require either the initial 3 weeks that the bank was given, and certainly not the request for an additional 3.5 months more. In other words, the bank was exaggerating the complexity of the task as a way of providing an excuse for not fulfilling it.
That's right. That's right. But that is the second stage. You see, the Supreme Court said, you tell us about the first stage. The first stage, there's no excuse.
Absolutely. Now, on Monday, when things seem to be going wrong, the state bank's lawyer, Harish Salve, said, and I'm quoting him, if there is no requirement to link the purchaser details with the parties, we can give everything within 3 weeks. In response, the court first drew Mr. Salve's attention to the fact that even the SBI's own submissions sufficiently indicate that the information is readily available. And then, rather than even grant the reduced request for 3 weeks that Mr. Salve has made, which is a huge reduction from the original position of wanting 3.5 months, the bank said, no, you will give everything within 24 hours, full stop. That's a second rebuke, is it not?
Yes, yes. And it's pretty obvious that from the time when the Supreme Court passed the order, okay, 14th, 15th of February, 3 weeks had already passed. So unless the State Bank of India was doing nothing and was just sitting on the information and doing nothing, it needed 3 weeks more. But since 3 weeks had already passed, and they would have done that exercise by now, so therefore give it 24 hours, give it by tomorrow. You couldn't have been sitting. If you've been sitting, admit it that you've been sitting.
In fact, that was an issue that was raised specifically by the Chief Justice of India. This is what he said on Monday. In the last 26 days, what steps have been taken by you? The application is absolutely silent on that. And he added, we expect a degree of candor from the SBI. In other words, the Chief Justice was indicating to the bank, you are not being candid. You are not being fulsome with the truth. You are not telling us what you've done.
Correct. And the bank did not answer that question. When the bank was asked, what have you been doing for the last 26 days? The answer was not given.
Absolutely. There was resounding silence, and that opportunity to answer was made to the bank 3 or 4 times, not just once.
Correct. So therefore, I think the court is entitled to presume that the bank was working on providing the information. They said we can provide it within 3 weeks. 3 weeks are over, 26 days are over. That's more than 3 weeks. So give it by tomorrow. Simple as that.
In fact, at one point of time, rather than answer that question, what have you been doing for the last 26 days? Harish Salve, who was appearing on behalf of the State Bank, said, and I'm quoting him, we don't want to now create any havoc by making any mistake. Else, he added, I will be sued by donors. And in response, this time Justice Khanna replied. He said, why would that happen? And then he added, there is no question of any mistake. You have the KYC. You are the #1 bank in the country. We expect you to handle it. So even this attempt at an excuse, I presume is what it was, that we don't want to make a mistake, we will be sued, was literally knocked for a 6 by the court, literally out of the discussion completely. They wouldn't accept that fear.
Yeah, you see, so therefore look at the entire, the hearing that took place. At every stage, there were problems that the State Bank of India was trying to create, right? Which were not accepted by the Supreme Court. So it's not that, one thing the Supreme Court agreed with and 5 things it did not agree with. It did not agree with anything at all. So obviously, the State Bank did not want to comply with the order, but found it difficult to say that, we don't want to comply with it.
And that is, in fact, a point that the Chief Justice once again picked up. He said on Monday, are you saying you're finding it difficult to follow orders? That was a blunt question that went to the very nub of the obstruction the SBI was putting up. And it's led many people to form the impression that the SBI cut a very sorry figure in court. Would you agree with that impression?
Yeah, it did. I mean, it's obvious that, the entire hearing and the entire sequence of events, clearly points to the fact that the SBI cut a very sorry figure. And the reasons are also fairly obvious.
So, in the public eye, the SBI stands embarrassed.
Yes, it does. At least in my eyes, it does stand embarrassed. And pretty badly embarrassed.
You would go as strong as that, pretty badly embarrassed.
Yeah.
Justice Lokur, the Supreme Court has also told the Election Commission to publish on its website all the information that the SBI will make available today by close of business by, forgive me, my apologies, sir. Justice Lokur, the Supreme Court has also told the Election Commission to publish on its website all the information given by the SBI today by close of business by 5 p.m. on the 15th of March. And also, they've been told additionally to publish previously given information given in sealed envelopes for the period before April 2019. Now, you raised this question a moment ago. Let me ask you bluntly, is there any possibility that either the bank or perhaps even the Election Commission will fail to comply?
I don't think so. I don't think so. I mean, if they fail to comply, they're inviting trouble. I mean, unless they want to invite trouble, they should comply with the order of the Supreme Court.
So you got the clear feeling that this time the Supreme Court means business. It is not in a mind to overlook and accept any excuse. If there is willful disobedience, which is the phrase the Supreme Court used, that happens again, they will take contempt action.
Yeah. In fact, the Supreme Court has already put the State Bank to notice, in a sense, that listen, you comply with our orders, or else we are likely to take action against you.
In fact, those are the precise words that were used in the order. You're now referring to the written order, the one that was dictated in open court. They actually use the language, we are putting the SBI on notice.
Yes.
They go on to talk about willful disobedience, inviting contempt action.
Right. That contempt action is taken only when there's willful disobedience. And what transpired indicates that there was willful disobedience, but the Supreme Court perhaps did not want to take action immediately. Give them a chance to purge the contempt. And if they do it, fine. If they don't do it, then you're asking for trouble.
Earlier in this interview, I asked you if there were many instances of a public sector company or a public sector bank placing itself in a position where it's been rebuked so strongly by the Supreme Court. Now I imagine this must also be a unique instance of a public sector bank being put on notice by the Supreme Court, and publicly at that, and told that if there is willful disobedience, we will take contempt action against you. This is again another first time for a public sector company.
Yeah, perhaps. I frankly cannot recall immediately of any instance where public sector banks have, willfully tried to circumvent or dodge the orders of the Supreme Court.
Let's at this point, Justice Lokur, broaden our discussion. Both in February, when the original order was passed on the 15th of that month, and yesterday, the Supreme Court has acted pretty toughly. And the Supreme Court has won a lot of praise for its response. Does this indicate a new assertiveness on the part of the court? A new, as I said in that introduction, firmness to stand up for the rights of Indian citizens?
Well, yes, I hope it is, but frankly, I keep saying that I am an optimist. And I know that the Supreme Court will act eventually in the interest of the citizens. So I hope it's a sign of assertiveness that we're not going to take all this lying down.
And therefore, if it is a sign of assertiveness, a sign that they won't take it lying down, I take it you welcome it.
Oh yeah, certainly, of course.
Then let me go one step further. Since the Supreme Court has deemed that the electoral bond scheme is unconstitutional, should it have ordered all recipient political parties to refund the money they received rather than permit them to retain what has now become unconstitutional funds?
Yeah, you see, it's a difficult question to answer, for a variety of reasons. One of them being that none of these political parties were before the Supreme Court, right? So the Supreme Court could not have given an order to them, to parties who are not before them, that you return the money. Okay, that's never done. Orders passed against parties who are not before the court. That is one thing. The second thing is that looking at it from a practical point of view, if the Supreme Court, assuming these parties were before the Supreme Court and the Supreme Court had said that you return the money, they could very well have turned around and said, listen, we spent it. Where are we going to get it from? So how do we implement the orders of the Supreme Court of returning the money? So it's an interesting question, but difficult to answer. And
in light of the fact that you hope that we're seeing a more assertive Supreme Court, let me ask you one more question. And I'm moving deliberately beyond the electoral bond issue we've been discussing so far. I'm talking instead about the constitutionality of an act passed by Parliament in December, which determines how election commissioners and chief election commissioners are appointed. This act, as you know, has been challenged in the Supreme Court. The Supreme Court has accepted the challenge. We don't know when it will hear the challenge. Prima facie, most people think that this act undermines the independent selection process that the Supreme Court itself believes is necessary to ensure the independence of the Election Commission and its integrity. Now, when in the next few days, it's very likely the government will be using that new law to appoint new commissioners, and that could have a substantial impact on the independence of the Election Commission. It could have a substantial impact on the forthcoming national elections. Should the Supreme Court stay the act? It's accepted a challenge against the act. Should it now stay the act and say, till we hear the challenge, you cannot implement something that we might end up striking down?
Yeah, but that's a very, very difficult question to answer. It's like this, we all know that the announcement of the elections is going to take place fairly soon, right? Perhaps this week. But anyway, supposing the Supreme Court stays the implementation of the act, what happens? Two possibilities are there. One is that, the government says that the earlier judgment of the Supreme Court, where they have this collegium which includes the Chief Justice of India, that gets revived. Okay. And so therefore the election commissioners will now be selected with this collegium, including the Chief Justice of India. That is one possibility. Another possibility is that, that judgment has outlived its utility, in the sense that after the judgment, what did the judgment say? The judgment said that until a law is made, we made a law now, okay, and you state that law, so the utility of that judgment has gone. So if you stay the judgment today, it means we go back to the pre-judgment situation, where the government alone decides who is going to be appointed as the election commissioner.
Can I interrupt at that point?
Yeah.
Do we really go back to the pre-judgment situation where the government alone, which means the Prime Minister alone, determines who will be election commissioners and who will be chief election commissioners? Because that position was firmly criticized by the Supreme Court and set aside by the Supreme Court on the grounds that it impugns the independence of the Election Commission, which they said was essential to the integrity of democracy. So surely, if the Supreme Court were to set aside or stay the Act of December, they would say you have to go back to what we suggested in our judgment, not to the situation that prevailed before our judgment.
Yeah, that's one way of looking at it. But then that decision, you're right. I mean, I'm saying that there are two options. But that decision will be ultimately taken by the Supreme Court. Okay. Now, in the meanwhile, supposing the two election commissioners are appointed before there's a stay, today or tomorrow, the two election commissioners are appointed. You can't chuck them out, just like that, without following any proper procedure. So really, while the question is academically very interesting, I'm not sure whether staying the law, will achieve any purpose at all.
Could I put it like this, Justice Lokur?
Yeah.
If at all the Supreme Court were to consider staying the law, they would have to do so before the two new election commissioners are appointed.
Yes. That is the first step. Okay. And secondly, whether we go back to the judgment, okay, that's a matter of argument. Do you go back to the judgment or do you go back to pre-judgment? That's a matter of argument. Now, to decide that, you have to go to the Supreme Court for a decision. Now, in the meanwhile, the elections will be announced. Elections will probably take place. I don't know.
It all depends critically on how the judges of the Supreme Court think. And in particular, I presume, how the Chief Justice thinks. A concern would be how important was his initial position that appointments by the government or the Prime Minister alone impugns the integrity of the Election Commission and therefore impugns its independence and vitiates elections. Secondly, how concerned is he that this is now going to happen because of an act that is already under challenge, but they haven't decided about that challenge? And thirdly, is he moved enough to want to move and act swiftly before the new election commissioners are appointed? Because then he may only have 2 or 3 days in which to act. It all depends upon how he views these critical issues.
Yeah. You see, that takes us back to an earlier point of delay in deciding cases of this nature. These kind of cases should be decided quickly. Don't wait for something to happen.
Well, I know that Jaya Thakur has already petitioned the Supreme Court requesting a stay on the implementation of the December Act. I believe from the newspapers, the Chief Justice indicated he will hold an early hearing. But whether that means he'd hold it between now and the appointment of the 2 new election commissioners, we don't know. And also whether he's moved to take the action and decisions you and I have been discussing, we don't know. But it is a fascinating academic question.
Absolutely. Yeah.
I thank you very much for addressing it with me, because even though we can't come to any conclusion, the discussion itself will open the eyes of the audience to the possibilities, but also to the problems. And that in itself is an education for an Indian electorate.
Yeah. Thank you, Karan. I think both the questions that you asked are academically very, very important. And let's see how the courts react and how the government reacts. That's also important.
Justice Lokur, thank you very much for this interview. A pleasure talking to you. Take care.
Thank you. Thank you. All the best.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times. And if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch The Interview. Your viewership means an awful lot to me.